Hi, and welcome to this edition of Ask an Attorney, joined today by Tyler Siewert. He is from the law firm of Schweiger, Clemeen, and McBride. Thanks for being here today.
Good to be with you.
Let's get right to the question. A questioner asks, I want to open a small business as a limited liability company so that I can protect my personal assets and have a separate bank account for my business. What steps do I need to take to make that happen?
Well, this is a fairly straightforward question, Wayne, but one that any person should be thinking about when making that decision whether or not to start a small business. So, beyond establishing a business model and accumulating startup capital, consideration of one's personal liability when starting that business, not only a smart thing to do, but quite necessary as well.
Okay. As far as protections for limited liability companies, what do they provide to owners?
Well, limited liability companies create a distinction between the company's assets and the personal assets of the company's owners. So if the company were to default on the repayment of a debt or has some sort of large court judgment against it, the company's owners are not going to be on the hook to pay for that debt unless they had signed any sort of personal guarantee and given it to the creditor. So the creditor can go after and seize the company's assets to satisfy the debt, but the creditor cannot go after the personal assets of the company's owners. And that's where we get the name Limited Liability Company.
Okay, how difficult is it to get a limited liability company?
Not at all, Wayne. Okay. Limited liability companies are state-recognized business entities. So this means that entrepreneurs could start a North Dakota Limited Liability Company, South Dakota Limited Liability Company, Montana, and so forth. So each state has its own laws that grant this limited liability to companies' owners for the debts and liabilities of the company. And the way I like to explain this is that in exchange for this limited liability, the company's owners agree to run and operate their business as a legitimate business enterprise. So in order to get a limited liability company started, the company's owners just need to file a document called an Articles of Organization with the Secretary of State of the state in which they desire to run and operate their business, and then continue to make yearly filings. So again, all that a prospective owner needs to do is file this acceptable Articles of Organization, pay a filing fee, then they're a recognized limited liability company.
So once they are recognized by the state, is the next step then, and is it easy to open a business checking account then?
Yep, it's just as easy, but even though a state may recognize a business as a limited liability company, every banking and lending institution is going to have their own respective requirements as well. And to begin with, every bank that I'm aware of is going to require the limited liability company to provide its tax identification number before opening up that company bank account. And in order to obtain a tax ID number, all the limited liability company needs to do is file an application with the IRS. But even once that's obtained, most banks are also going to require the limited liability company to provide a copy of its operating agreement before opening up that bank account.
Okay, you bring up operating agreement. What is that?
Yep. An operating agreement is going to be the limited liability company's chief governing document. And this document can be as expansive or as limited as the company's owners desire. But generally, it's just going to set forth the identity of the company's owners, voting rights, managerial duties, and all of the other privileges and obligations of the company's owners. But as importantly, having an operating agreement in place is one way to prevent courts from piercing the corporate veil to hold the company's owners personally liable for any company debts or liabilities.
Okay, we're down to under a minute. Piercing the corporate veil, what is that?
Well, even though I mentioned to you earlier that operating a business as a limited liability company is one way to protect the personal assets of the company's owners, that's not always going to be the case. So in rare circumstances, courts can actually pierce through this liability protection and hold the company's owners personally liable for company debts. And I'll go back to what I said earlier about operating the company as a legitimate business enterprise. If the company's owners fail to do that and the business is undercapitalized, failing to follow the law, or there's just really no distinction between the company and the company's owners itself, Those are the circumstances under which a court can pierce the corporate veil. But again, having an operating agreement in place is one way to prevent courts from doing that.
All right, Tyler, thank you very much. Good information, and thank you very much for being our guest today. This has been Tyler Siewert from the firm of Schweiger, Clemene, and McBride. A quick reminder for you, the information that we've talked about here does not pertain to all cases, and for more information, you should contact an attorney.